Good morning, Ms. Manning.
Commonwealth versus O'Brien.
Mr. Malkovich? Thank you.
Good morning. Michael Malkovich for the appellant, Patrick O'Brien. This case gets to the question of what constitutes coercion with respect to having a defendant waive his right to remain silent and to voluntarily offer a statement. In this particular case, the most important piece of evidence against the defendant was a written, signed confession that was taken from the defendant by the Worcester Police. It's significant to look at a few of the facts. At the time that the defendant was arrested, the case had already been investigated for, I don't remember exactly the number of days, but they had not really pinned down a defendant. The police were obviously interested enough to get this confession that they interviewed him for 3 to 4 hours.
Well, at that point, did they have a description of the assailant?
They had a vague, as I understand it, they had a vague description, allegedly a witness who saw an individual running up the steps of the defendant's home, or his father's home where he was living, roughly around the time, shortly after the incident. That's probably the closest they have to a description.
He was a suspect.
He was a suspect.
Almost immediately after.
They, fairly soon afterwards, I think they were able to, with the location of evidence between the location of the crime and where the defendant was living, they were able to pinpoint him as a suspect. They had questions, apparently, as to who was actually involved, and that seemed to be part of their interrogation of him was to ascertain.
Now, let me just ask one other question. At some point, they found a number of different items that had been dropped in a culvert or something like that, as I recall.
That's correct.
And how soon were these items discovered after the crime?
I don't know exactly, but I believe it was within a few days of the incident. They found they located the vehicle that had been driven from the scene, and in a fairly close proximity to the vehicle.
And the items were also found in close proximity
to the vehicle, and if the vehicle was between the location of the incident and where the defendant was living. So they may have been piecing things together, but at that time, the time they picked up the defendant, they actually picked him up on an unrelated default warrant in district court and began questioning him about the incident. They questioned him for 3 to 4 hours, and during that time he denied any involvement in it, expressed no indication that he intended to cooperate with them. He had previously had exposure in the judicial system, so he was well aware of the rights that he had and the ability to not have to give statements. There's indication that at one point he attempted to locate or contact an attorney. Attorney Salerno was unable to do that, and at the end of that, apparently that's when the questioning ended. He went back to the county lockup. The police then brought in the defendant's father, who has essentially been the primary figure in this defendant's life, the only person who really has any kind of a close relationship with him. And according to the testimony of the father, they indicated to him that a number of things. They indicated that they had offered a manslaughter plea, that the defendant had rejected that. The officers, and this isn't in dispute, the officers told the father, if he could talk to us, if he cooperates, he may see the light of day by cooperating with the police.
They actually offered him a manslaughter?
Well, this is in dispute. The Commonwealth will say it was not offered. The detectives deny it.
Did the judge make a finding on this?
Well, there was a motion to, well, there was...
Well, I know there was a motion to suppress. Did the judge make a finding that they offered him a plea?
I believe the finding of the judge would be that there was not a plea offer made.
Well,
that's essentially the facts that the courts have been operating under.
I mean, your argument, as I understand it, centers mainly on the fact that they said to the father, and words or substance, you know, he may be able to see the light of day if he cooperates with us, correct?
That's correct.
Yeah.
Yeah, and the manslaughter is the one that's in clear opposition by the Commonwealth. The defendant's father testifies that was said to him. The Commonwealth vehemently denies that, but what they do not deny was that it was, you may see the light of day if you cooperate. Now, in Judge Hillman's findings on the motion to suppress, it's interesting to note that that specific statement is not found in any of his summary of the findings that he reviewed when he issued his motion. I don't know why that is. I would suggest that that's probably the most significant item in that set of findings for the motion to suppress. Because
What was the exact testimony? You will see the light of day if you do what?
if you can cooperate,
Well, that's a little different than
you may.
confess.
If you cooperate, if you cooperate with us, you may see the light of day.
All right, so they did not say if you confess, you'll see the light of day.
That I would have to go back and review the record to
Okay.
see if it was exactly that wording. I don't want to misrepresent that to the court. But what was conveyed was that by working with the police, the defendant would see the light of day. This was told to the defendant, and it was told to the defendant's father.
Was it he would see or he might see?
He might see the light of day. Now,
Mr. Malkovich, may I ask you this? Before the police spoke to the defendant's father, had the defendant spoken to his father?
he had been in contact, not my assumption, and I don't know this for a fact, there had been communication between the defendant and members of his family after he had been arrested. He was being held for, he had been in there for a few days before they even began questioning the father.
Were the police telling the father that they knew the defendant had committed this?
They were presenting what they felt was some compelling evidence.
Okay.
They, I believe, paraded all of the things that had been recovered from the catch basin to the father, and I believe they may have also told the father that they had a witness who could place somebody entering the defendant's house shortly after the incident. So I think that they they made it clear to the father that they felt they had some significant evidence.
Is it your position that police should not talk to family members?
Well, I think I wouldn't take that position because I think that would tie the hands of the police to suggest that they couldn't interview family members. But I think in this particular instance, there was a concerted effort to use the father, not just to talk to him to get information, but they admit this in their testimony, they knew that he would talk to the defendant after they spoke to him. They showed him a compelling
Well, let me just stop
case.
you there. Wouldn't you agree that in almost every situation where police speak to a family member, it's likely the family member would then talk to an accused person about their contact with the police?
I think that's a fair assumption.
Okay, so let's go forward with that. That wouldn't be a problem then.
That wouldn't be, and one could assume that's going to happen, but what's probably more germane is to plant in the father's mind this idea, one that's not disputed whatsoever, and the other one that is disputed between the defendant and the Commonwealth. The first that's not disputed is this see the light of day comment. That's undisputed.
But,
That
by
was
the
put
way,
in the father's mind to bring to the defendant.
After the judge made his findings, you made the point that the judge made no reference to the statement, he may see the light of day. Did you go back and ask the judge to reconsider adding that language to his findings?
I did not. There was a clarification. The trial counsel did go back at some point, and the judge did issue a clarification on his findings with respect to the motion to suppress, but it didn't have anything to do with that specific comment. No. And the simple answer is no. We did not go back on that issue.
But the judge did find that there was no assurance that was made by the police, didn't he?
Well, what he found was that he concluded that what was said to the defendant and to his father was that they would bring this to the district attorney. If he cooperated, they would bring this to the district attorney, and that the district attorney might look favorably upon it. I don't even think they went that far. The judge sort of concluded that all that was conveyed to the defendant directly or through his father was that it would be brought to the district attorney's attention. And in cross-examining the officer about this light-of-day comment, he's very evasive about what that means. He doesn't give a very logical explanation as to what he intended to convey either to the defendant or to his father by this light-of-day comment. He kind of suggests, well, I don't know. I wouldn't suggest that he could get any result as a result of cooperation. And I think that's the difference between saying that you'll bring something to the district attorney if he cooperates versus you may see the light of day. May see the light of day is a result-oriented comment. This is an objective you would hope to obtain. The other one is simply saying that you will be perhaps treated more favorably, but it's not focused on what type of outcome you could expect. I think it tortures the language to suggest that offering to the defendant facing a mandatory life sentence that you may see the light of day if you cooperate. I think it's kind of hard to suggest that that's not offering something less than a first-degree murder conviction. I think that's taking it in not even taking the defendant's position as strongly. I would suggest that it tends to work hand in hand with what the defendant represents, which was that there was a manslaughter offer that was suggested to the father. It's consistent with that. There is some consistency in that. The bottom line is that it's a combination of factors. It involves bringing in a very close family member, presenting the light of day comment to this family member in dispute, suggesting that there was a manslaughter offer that had been made and rejected, and then there was also this issue of minimizing the offense to the father, suggesting that the police had reason to believe that it may have been an accidental shooting. Again, that wasn't disputed either, that the police suggested to the father that it may be accidental. So you can say, well, the Commonwealth has denied all of this. They say that's not what happened. But if you look at it from if you put those pieces together, I think it suggests otherwise. And I think when you look at the fact that you have a defendant who, for 3 to 4 hours, gave no cooperation, and then one day after his father meets with the police, he goes and has a short meeting with his son and is told by his son to bring the police in because he's ready to cooperate. There's no question that his decision to make a confession was directly related to the father coming to him, and it's a sequence of events that also supports the suggestion that there was something conveyed to the father that made this defendant do a complete about-face with respect to his cooperation and come forward with no other explanation as to why he's giving this confession, simply sign a full confession on the
You think that's
first-degree murder.
the only inference that could be made from the sequence of events?
Well, it's not the only inference, but if we're looking at the possibility that that is, if we're looking at establishing that waiver beyond a reasonable doubt, I think that that's the combination of factors is sufficient to raise some serious reasonable doubt about whether that waiver was voluntary or whether there was coercion. And unfortunately, and this ties into the second argument, I understand that the D. Giambattista is viewed prospectively as a superintendent's rule of the
Well,
court.
let me back up a minute. Was there any argument that was made that the attempt to, or that when the police suggested that there might be a light of day here, that they were trying to get the defendant, or that they were trying to perform an end run around the Edwards v. Arizona case? And get the defendant to talk after he had exercised his right to speak to an attorney?
Well, I think that bringing the father in was an attempt to get around the defendant's...
Was that argued below?
That was argued, I believe, at the motion to suppress as well as at the trial. It was a suggestion made that the father testified at the trial.
No, but Justice Fiena's question is there a claim made before the motion judge that the defendant, everybody concedes, recognizes, had exercised his right to remain silent and had invoked his right to have an attorney? The police didn't question him further. They questioned his father. Was it argued that that was an attempt to end run the invocation of his right to remain silent and his right to speak and his wish to speak to an attorney.
I believe it was argued that the police used the father to persuade the defendant to give up his right.
What right?
Not his right to remain silent and to persuade him to voluntarily provide a statement. I think it was a question of bringing the defendant on board, not so much, I don't know if there's a clear distinction between doing an end run over his right to remain silent, but I think that they used the father knowing that he would be the person who could, if anybody, persuade the defendant to change his position.
Now, let me put it this way. The defendant says, I don't want to speak to you. You then get somebody in whom the defendant has enormous confidence. The police pull that person in and say, you go and persuade your son, whoever it is, to speak to us. Regardless of whether there was an inducement, it would be in his best interest. We know you support justice in this society, whatever the claim is that permissible?
Well, I'm not sure that you could make a hard and fast rule to say that you should never be able to do that. I think you'd have to look at the individual circumstances, and in this particular case, those circumstances include the fact that this is a particularly important relationship, that the police had reason to believe that the father was the person who would be most persuasive, and that they chose the father for that reason. There was a sister. They could have brought the sister in. They could have questioned the mother, but it was the father they chose, and the inducement they gave was the kind of thing that you would tell a father who would expect to pass on to his son, that this is in your best interest. You can help yourself if you cooperate. And if we take what the father testified as true, then it's not only that you can help yourself, but why did you refuse this offer when it was given to you?
But was that argued below on the question of voluntariness, or was it argued as a way to try to get the defendant to trick him into giving up his Miranda rights? Exactly how was it?
I believe it was argued in terms of coercion.
On the issue of voluntariness.
On the voluntariness issue. Because I don't think that the defendant understood his right to remain silent. This wasn't the first time he'd been held by the police, and he was aware of that. I think it was simply a matter of using somebody who was close to the defendant to persuade him to change his position. He held out for 3 to 4 hours in the initial interview with the police, so I don't think that they tricked him, per se, other than to plant in his mind that this was something that was available to him and fed it to him through the father. Now, that goes into this issue of the absence of the recording.
Can I just ask you this question about the recording, Mr. Malkovich? Even assuming that we were to apply DGM Batista to this case, which is dubious, it wouldn't cover the police conversations with the father, which is where you claim all the inducements occurred.
Well, that's true. However, what it would convey is the discussion between the defendant and the police officers, which unfortunately, and this is the problem with, as the court's recognized in its decision in DGM Batista, is that if you have very little information recorded by the officers doing the interview, then there isn't, most of the information was lost. Out of the sum of about 4 to 5.5 hours of interviews with this defendant, we're left with the 4-page written confession, which was basically question and answer dictated by the officer doing the interview, and a couple of pages of notes. That's 4 to 5.5 hours worth of an interview. There was a lot more said, obviously, in the discussions with the defendant, and we just don't have any ability to evaluate that. The officers, when they spoke to the defendant the second time after the defendant had spoken to his father, there was a lot more information conveyed than simply, this is my statement. There were undoubtedly discussions about what had transpired, the fact that the father had asked the police to come in and talk to the defendant. It was the defendant who initiated having the second interview take place. And I don't think that's insignificant. And I would just suggest that what DGM Batista offers is that the courts clearly recognize the problem when you have a confession that's not recorded, that there's so much information and there's so many questions about what actually transpired that can never really be answered. And in light of the facts in this case, I would suggest that the Court can consider the rationale behind the Di Giambattista ruling and assess whether this truly was a coercive environment, whether that was reasonable, whether they proved beyond a reasonable doubt that the defendant voluntarily waived his rights. And I would suggest that the evidence here suggests that he didn't.
Thank you, Mr. Malkovich.
Thank you.
Ms. Lazar-Moore.
Good morning. Ellen Lazar-Moore for the Commonwealth. Judge Hillman correctly determined that the defendant's confession was voluntary because he correctly found that the statements made by the police to the defendant's father did not amount to an assurance of leniency.
Was there any claim that this was an end run around his invocation, of, as Justice Spina said, of either, his Miranda rights, but also his attempt to obtain an attorney?
Yes, Your Honor. I believe that the defendant's attorney did argue in one of his written motions to suppress that this was, as you put it, an end run around his invocation of the right to counsel, right to remain silent. He did put that in the written motion. He did not argue it at the hearings on the motion to suppress, and Judge Hillman did not explicitly rule upon that claim. And then there was no request to reconsider that claim, and of course the defendant did not raise it on appeal. But I would just briefly say that in my opinion, I don't think that, now, Detective Quinn, who was the officer who made the statements to the defendant's father, testified throughout that the main reason for the interview, and I don't think this is disputed, was because the defendant's father was with him on the day of the killing. And so the main purpose of the interview was to ascertain the defendant's activities on that day and his whereabouts. It was within this interview that Quinn made the statement to the father about seeing the light of day.
Did the defendant have a lawyer at the time the police interviewed his father? Looked like there was At the time the police interviewed his father, I'm not sure. When the defendant was arrested on June 6th on a default warrant in an unrelated case, and when he said that he wanted to try to call this particular attorney, Salerno, the police said okay, and they gave him a telephone and a telephone book. Yeah.
It's not clear whether or not he made the call. There's some indication that he did and some indication that he didn't, but in any event, that's the only mention that we have of any sort of attorney involvement in the case.
But the police interviewed his father, I think, on June 9th.
Yes.
And it was on June 11th that the defendant said word back to the police.
I think it was actually on the 10th.
On the 10th.
But in any event, yeah. But there's no indication up until that point.
Do you know when he was arraigned?
Well, he had not yet been arrested for the murder until the 10th, and Quinn met with the father on the 9th. And so it would only have been in connection with the other case on which he was being held, where he had been arrested on the default warrant, that he might have had counsel in relation to that case. We know he didn't yet on the 6th because he was asking to call this attorney Salerno, and it didn't seem in context that he was claiming that Salerno was representing him. It was more just, I want to try to call this lawyer.
Yeah. Because we have to give this case 33E review, I'd be interested in your thoughts as to why this is not a violation of Edwards v. Arizona.
Well, as I said, the defendant hasn't raised the claim, so I'm not fully prepared to address it.
But we're going to raise it.
What I would say, yes, I realize that. What I would say just briefly is that I don't believe that telling the father in the context of an interview with the defendant's father about the defendant's whereabouts on that day, just saying that what might happen if the defendant cooperated would be the equivalent of interrogation of a defendant. I mean, Quinn told the defendant's father that the police would, I assume, well, he said, I told Mr. O'Brien we were interested in getting the truth, and that if Patrick told us the truth and cooperated, including others who might be involved, that I would tell the district attorney, and he may see the light of day down the road. That it would be my opinion that that would not be the functional equivalent of interrogation to violate the rule in Edwards versus Arizona. But as to the claim that the defendant is
Excuse me,
raising...
Ms. Lazar, and you were leading from the testimony at the motion hearing?
Yes, the transcript from January 7th of 2002, that was on page 8. So Judge Hillman correctly found that this was not any sort of an assurance of leniency or that it would benefit the defendant's case, but rather that it was only a broad statement that cooperation by the defendant would be brought to the attention of the district attorney and that it may benefit the defendant. So this is akin...
May I ask you a question just to follow up on Justice Spina, which is not this case, I understand, but let's assume that a defendant has invoked his right to remain silent pretty consistently for 3 to 4 hours. Is it permissible for the police to call in a parent, somebody close, and say, you know, why don't you persuade your child, your son, your spouse to talk to us? It may help them see the light of day.
I think it would depend on the exact language and the exact circumstances. I think that would be a different case because in that case it's possible that an argument could be made that the parent was then being used as an agent of the police. If the police are explicitly saying, essentially, your son doesn't want to talk to us, see if you can get him to talk to us, I think that that would be a different case than to say in the context of an interview about the defendant's whereabouts, you know, if he cooperated, we would tell the district attorney and see what happens.
In other words, the police had a separate independent reason for interviewing this father as a potential witness.
Yes, they did, and it was 3 days later.
But why would they tell the father that it would be in the son's best interest to cooperate?
Well, I have no doubt that they thought that the father would communicate this to the defendant. But I do think that it's a different case than explicitly calling in a parent and trying to persuade the parent to persuade the child to waive a right that the child has just invoked.
If the defendant had invoked his right to a lawyer, invoked his right to silence by invoking his right to, and invoked his right to a lawyer, as he did here, could the police have immediately said to him, well, that's too bad, because your cooperation would have resulted, or could have resulted in some benefit to you? Would that have been an appropriate statement to have made upon the defendant's invoking his right to silence through invoking his right to an attorney?
Right. I guess in my mind I'm trying to sort through. What the question is whether what is said to the defendant is the functional equivalent of interrogation, and that it is an intentional attempt to try to elicit an incriminating statement from the defendant.
It's not just interrogation. It's to not scrupulously respect the invitation of his right to remain silent. It doesn't necessarily have to be interrogation, I don't think.
Well, I think that the intent has to be to try to elicit some sort of an incriminating response from the defendant. And it may be, again, that in particular circumstances, that may be seen as sort of an invitation to reopen the questioning, and that it's possible that it might be. But again, in the circumstances here, I think that this is an interview had with the father 3 days later on a particular subject, the defendant's whereabouts at the time of the crime, and that for the detective to say this to the father in the context of that conversation and not to specifically ask the defendant to talk to them or anything of that nature doesn't rise to the level of trying to reinitiate an interrogation or opening up any sort of new communications. And of course, if the defendant wanted to talk to them, that would be his choice, and indeed that's what he did this time. So again, as to the claim that the defendant is raising, the judge here explicitly did not credit the defendant's father's testimony that the officer had offered the defendant a manslaughter charge. He then correctly concluded that the officer's other statements about the defendant cooperating, that the district attorney would be informed of any cooperation and that the defendant may see the light of day, did not amount to any assurance that the defendant would receive leniency. And that the defendant did not confess in exchange for a promise of leniency is actually shown by his own actions. First, before the defendant's father ever spoke to him to tell him of his conversation with Detective Quinn, the defendant earlier in that day actually called his mother and said, "Send Dad up, it's time to suck it up," sort of implying that he was ready to confess even before hearing anything about this meeting with Detective Quinn. Second, when the defendant...
And that comes in through...
That comes in also at the suppression hearing on January 7th on pages 64 and 65, and this is a telephone recording of that the call the defendant had made from the jail to his mother. Second, when the defendant met with Detective Richardson to confess, he made no mention whatsoever of manslaughter or any other reduced charge or any type of leniency. He just walked into the room and said to Detective Richardson, "I'm your guy. I did the Il Palazzo." So had the defendant been confessing in exchange for an expectation of some sort of leniency, he certainly would have been expected to mention that before confessing, during, or after, but he never mentioned this at all to Detective Richardson. Then after he made his confession, he made repeated statements to a correctional officer at the jail whom he had known from high school, and then also to family members on the telephone to the effect of life, I'm getting life, I'll get life for murder one. So again, Judge Hillman found correctly that these are not the words of someone who thinks that he has made a deal for leniency. They show the defendant's expectation that he will be facing life imprisonment. And the defendant also told this correctional officer that he had confessed because he did it, and he did not want other people to be blamed. He did not say anything like, well, I confessed because they told me that I would get manslaughter or some lesser charge or anything of that nature. So because all of these circumstances show that the defendant's confession was voluntary, Judge Hillman correctly denied the motion to suppress. As to the claim regarding the deed...
In those statements that he made to the other person in the jail,
Yes.
they're going to come in anyway.
Right.
Right. Well, right. There was
I
no...
mean, he not only confessed to the police, but he made admissions to somebody else that are going to get into evidence. They're going to get into evidence.
Right. He made these admissions unsolicited to his correctional officer whom he had known. Correct.
And you don't see any reason here which would cause us to revisit D.G. Batista and make it retroactive to this case, do you?
No, I certainly do not. Besides, of course, that the court explicitly made it prospective only, as Chief Justice Marshall pointed out, in this particular case, even if the instruction should have been given or had been given, there was no dispute as to what happened at the defendant's two interviews with the police. The only dispute centered... Excuse me?
Well, the defendant didn't testify, right? Or did he testify at the motion?
He did not testify at either hearing, but he, through cross-examination of the police officers or anything of that nature, he never called into question what happened at those interviews.
This is really a non-issue, isn't it?
I think so, but where the defendant was raising it, I felt that I should address it. I just wanted to say that, as Your Honor pointed out, that where there would have been no recording of the father's interview with the police and everything really centered around that it wouldn't have benefited the defendant anyway.
Of course, if the father's being interviewed as a witness, then his statement would be recorded as well under D. Giambattista.
Well, no, D. Giambattista says when the statement or confession is admitted against a defendant in a criminal trial.
Well, it might not have been. I assume at some point the police don't quite know who they're going to indict or not indict, but that's a...
Yeah, although in this case there was no question that the father was not a suspect.
Could I just ask you, does the Commonwealth really take the position that the reasonable doubt instruction is correct, as opposed to there's no substantial risk of a miscarriage of justice?
Yes, Your Honor, we do. In fact, it was almost a verbatim recitation of the Webster standard.
But the almost a verbatim is the problem with Webster. I mean, I won't press it, but it is a garbled description of Webster. But it may be that there's no substantial risk, but...
Well, certainly I would say there's no substantial likelihood of a miscarriage of justice, but I also am of the opinion that the instruction was correct. It was almost a verbatim recitation of Webster, and the only portion of Webster that was not stated was the very last sort of half a sentence about conscientious jurors. And I think in the context of this obviously very serious first-degree murder trial, as well as the fact that the judge made the jurors stand before he gave the Webster charge to highlight the importance of it, that certainly the jurors didn't need a reminder to be conscientious. And the judge also, after completing the Webster portion of the charge, included language where he contrasted mathematical certainty with proof beyond a reasonable doubt, and this court has actually commended that language. And in Commonwealth versus Mack, where Judge Mulligan also presided and gave a reasonable doubt instruction, which seems almost identical to the one here, the court said that it was exceptional. So, yes, it is the Commonwealth's position that it was proper and certainly no substantial likelihood.
I'm curious about one thing. Your brother made reference to the fact that the judge did not make a specific finding about the light of day statement.
No.
What are we to make of that?
It seems from his findings, as I read them, that he didn't specifically quote the language that was used by the officer. He just said generally that the officer's statements to the father did not amount to an assurance of leniency, and that instead they amounted only to a statement that the officer would communicate any cooperation to the district attorney's office.
But you don't dispute that the statement was, if he cooperates, he may see the light of day.
Yes, that, right. If he cooperated, that he would tell the district attorney, and that he may see the light of day down the road was the statement, and we don't dispute that. I don't think that the judge ignored it, although he didn't explicitly quote the language. I think that he was more just generally discussing the statements that had been made as opposed to quoting them explicitly.
I take it that the Commonwealth didn't dispute that the statements were made at the hearing on the motion to suppress.
No, in fact, it was the Commonwealth who brought forward the officer, had the hearing reopened, and brought the officer forward to testify to exactly what was said. If the Court has no further questions, I would rest on my brief.
Thank you, Ms. Miller.
Thank you.